Good morning. I deeply appreciate the privilege of occupying this platform to briefly address the legacy of the Ad Hoc Tribunals and how I see the future of international criminal justice as the Ad Hoc Tribunals near the end of their mandates. I first would like to thank Professor Meyer-Swart and all of her colleagues from the South African Institute for Advanced Public Constitutional Law and Human Rights Law at the University of Johannesburg for organizing this conference. I would also like to welcome and thank the distinguished presenters, panel members, and other participants in this conference. Since the general theme for this conference is the legacy of the ICTR, I think a critical question to consider before we get started is why we have international tribunals in the first place. The question seems simple enough, but even those of us who have dedicated the better part of our careers to international law could benefit from the exercise of recalling why we are really doing this work. Despite our judicial engagement with the trials, our proximity to victims and alleged perpetrators in the courtroom, our genuine sympathy for the aggrieved, and our earnest pursuit of justice, it is all too easy to miss the forest for the trees. Consider the question of why we have international tribunals in the context of the ICTR. An estimated 800,000 people, mostly of the Tutsi ethnicity, were killed in a 3-month period during the 1994 Rwandan genocide. By November 1994, most Rwandan judges and lawyers had been killed or had fled the country. The new government had to rebuild the country and its institutions, an endeavor that included the prosecution of more than 120,000 alleged perpetrators at various levels who were accused of committing crimes related to the genocide. During the intervening and formative years of the Gacaca efforts, and while Rwanda was focused on rebuilding of the national courts, its newly formed government was simply incapable of tracking, arresting, and trying some of the highest-ranking former military and government leaders and other high-profile fugitives who had fled the country in the wake of the genocide. Thus, the UN Security Council established the ICTR after an initial request for assistance by the Rwandan government and in the face of no other alternative for trials of those accused of being most responsible for the planning and execution of the genocide. The member states recognized that the destabilized region would impact other endeavors of the international community. Consequently, the ICTR was to have a broad impact, including helping to bring reconciliation and restore peace in the region in the wake of the conflict. The decision by the Security Council to establish ad hoc judicial mechanisms such as the ICTR and ICTY was at first met with some critical opposition. This was immediately addressed by the ICTY in the seminal Tadic case. There, the appeals chamber noted that the only exception to the doctrine of non-interference is for enforcement measures ordered by the Security Council to maintain or restore international peace and security, and that such measures are not limited to the use of armed forces. The creation of the ICTY and ICTR was therefore considered to be a valid exercise of the executive powers of the Security Council in the maintenance of international peace and security under Chapter 7 of the UN Charter. Unfortunately, this part of the tribunal's mandate is often lost in the discussions about the greater battle against impunity. Too often, these tribunals are seen to focus solely on retributive justice and other equally important core functions. The pursuit of peaceful resolution of conflicts and ushering in of national reconciliation falls by the wayside. But in the pursuit of justice for violations of humanitarian and criminal law, it is surely the efforts with respect to both aspects of the mandate that are the true legacy of the tribunals. Thus, the International Tribunal is a creature of necessity, Where there are gross violations of international law and legal proceedings in national courts are unattainable, or there is evidence of unwillingness to prosecute, the International Tribunal represents the promise for accountability and justice. This is, of course, based upon the idea that an international tribunal will have institutional capacity, investigatory wherewithal, state cooperation in investigating and arresting suspects, and impartiality. It is difficult not to recognize the impact that the creation of the ICTY and the ICTR had on the evolution of international criminal law. In that regard, I would now like to discuss some of the jurisprudence and capacity building initiatives emanating from the ad hoc tribunals, as they play an important role in their legacy and in the development and future of international criminal justice. From the beginning, in the fulfillment of the mandate, the judges of the ICTY and ICTR were cognizant of their role in crystallizing international legal concepts and providing a model for domestic judiciaries to follow. In the early judgments, the chambers codified numerous facets of international criminal law and international humanitarian law that were at that time undeveloped. The seminal ICTR Akayesu judgment was the first conviction by an international court for the crime of genocide, and the judges in that chamber were the first to interpret the definition of genocide as set out in the 1948 Genocide Convention. Additionally, these tribunals played a pivotal role in developing the standards used to adjudicate cases involving sexual violence crimes. While the ICTY Koranach judgment was the first case in the history of international criminal law to convict only on the ground of sexual violence, the ICTR Akayesu judgment was the first conviction for rape and sexual violence as a form of genocide, and the first time that an international court interpreted and applied the definitions of rape and sexual violence in international law. For my part, I was a member of the trial chamber which heard the Karamera case, and in the trial chamber we considered rape to have been a natural and foreseeable consequence of the genocide campaign. This marked the first time men were convicted under the extended form of joint criminal enterprise, JCE, for acts committed by others which were a natural and foreseeable consequence of the greater JCE plan. Though this is a concept that was first introduced in the ICTY Tadic case in 1999, the Karamera trial judgment was the first application of this kind, and it remains to be seen whether it will stand on appeal. Furthermore, both the tribunals interpreted the UN Convention Against Torture, UNCAT, in groundbreaking ways. The aforementioned Akayesu case and the ICTY Forondija case studied the co-perpetration of such crimes, and in Forondija the chamber recalled that the prohibition against torture is a peremptory norm, therefore accepted by the international community as a fundamental principle from which no derogation is permitted. Moreover, the ICTR Bedanin case reaffirmed the relevance of the definition found in UNCAT and explored the importance of taking into account the subjective elements of an act of torture related to the victim's condition and the circumstances in which that act takes place. It also supported the idea that international crimes can be the result of omissions. The ICTR was also the first international tribunal since Nuremberg to hand down a judgment against the head of government. The judgment against Jean Kambanda, the Prime Minister of Rwanda during the genocide, showed that no individual enjoys impunity for crimes on account of their official position. The ICTR further impacted the development of international criminal law by providing the first modern examination of the role of the media in the context of mass crimes, and the first thorough analysis of direct and public incitement to genocide in the media judgment. In that case, the ICTR clarified the application of the Geneva Convention to civilian perpetrators by holding that civilians can be held accountable for war crimes when they actively participate in the hostilities. Moreover, international criminal law has been essential in the development of customary international humanitarian law. For instance, the ICTY Tadic case is often referred to for its explanation of the notion of unnecessary suffering in regard to the limitations of the use of weapons. Thank you. Also in that case, the classification of armed conflicts was examined, and it was determined that the general essence of the rules of international humanitarian law applies to internal conflicts, which resulted in a clearer distinction between international and non-international armed conflicts. As such, international criminal law represents a key measure to the implementation of the law of armed conflicts and an important measure for sanctioning human rights violations. Thus, the few examples above demonstrate the instrumental role that the jurisprudence from the Ad Hoc Tribunals played in the evolution and development of international criminal law. I would now like to take this opportunity to make a few remarks on the outreach programs created by the ICTR. A panel will discuss the ITR's outreach and capacity building initiatives in more depth, including the ICTR initiatives to foster the development of national and regional judicial institutions. Therefore, I will just make some brief general remarks on this topic. These important programs ensure that the legacy of the ICTR is not only its judicial decisions, but also the knowledge gained and lessons learned with respect to running a judicial institution, in particular with respect to trying those accused of international crimes. The efforts and contributions from the ICTR have been vast and have resulted in the sharing of expertise and know-how on the prosecution and administration of criminal justice in countries such as Rwanda, Kenya, Tanzania, Uganda, and Zambia, and the running of an international court with the ECOWAS Court, the African Court of Human and People's Rights, and the Caribbean Court of Justice. This includes continued involvement by current and former ICTR principals and senior officials in judicial and administrative conferences and seminars, as well as capacity building and training programs spearheaded by the ICTR prosecution and registry. Though we are all engaged in working to share what we have learned at the ICTR, the prosecutor and his staff deserve praise for being the most active when it comes to best practices sharing. In fact, I'm very happy to have this opportunity to congratulate Prosecutor Diallo and his staff on the Special Achievement Award that the Office of the Prosecutor received last month from the International Association of Prosecutors for its significant and important work in the fight against impunity and for taking the initiative to establish a manual of best practices on the tracking and arrest of fugitives from international criminal justice that can be used by national and international prosecutors around the world. In order to ensure that the affected communities not only understand the work of the tribunal, but also the ramifications of the genocide and lessons learned in our battle against impunity, many of the outreach programs have also focused on education through mass media and other modes of widely disseminated communication. Further, in order to ensure that the ICTR legacy is preserved, the ICTR has created a legacy committee that is currently making arrangements to establish an ICTR legacy website that will be run by our successor, the Mechanism for International Criminal Tribunals, the mechanism upon our closure. This website will provide an even larger database of ICTR judicial decisions, case law, speeches, best practices materials, audio and visual materials, and a wide variety of other records. The Legacy Committee is also planning events to commemorate the 20th anniversary of the 1994 Rwandan genocide and the creation later that same year of the tribunal. These events will further highlight the contributions that the ICTR has made to the process of peace and reconciliation in Rwanda. I believe this is an important step in keeping with the concept that justice mechanisms, whether internationally or domestically organized, must not only do the justice, but also be seen to be doing justice by the people affected, if the judiciary is to be respected. Now, turning to the future of international criminal justice, I think that there's no question that the proliferation in the past decades of hybrid tribunals and the creation of the ICC are steps in the right direction vis-à-vis building and sustaining global confidence in international justice mechanisms. One criticism of the structure of the ad hoc tribunals was that the courts did not allow for adequate participation of the people most affected, and that while the ad hoc tribunals do benefit from the participation of victims as witnesses, victims did not have the opportunity to participate in their own right due to the geographic location of the ad hoc tribunals and non-integration with domestic courts and jurists. This was addressed when creating the next generation of tribunals following the ad hocs. The creation of hybrid tribunals where the state involved retained ownership of the proceedings due to the application of their national laws and participation of their judges has led to great progress, in particular improved perception of the affected societies. We have seen this in all of the hybrid tribunals based inside the state concerned. For instance, the Special Court for Sierra Leone, the extraordinary chambers in the Court of Cambodia, the special panels of the Dili District Court in East Timor, and the hybrid court system practiced by the United Nations Mission in Kosovo. On the other hand, the ICC, while located in The Hague, operates within the parameters of respect for state sovereignty with its complementarity approach to the prosecution of crimes within its jurisdiction. In the same vein, the ad hoc tribunals, and now the mechanism, have developed legal standards for the referral of cases to domestic jurisdictions. These referrals serve as a precursor, albeit a concurrent one, due to the timing of their application, to the complementarity principle of the Rome Statute. This principle entails that the ICC can only investigate and prosecute core international crimes when international jurisdictions are genuinely unable, when national jurisdictions are genuinely unable or unwilling to do so. Thus, the complementarity principle provides yet another safeguard towards the prosecution of gross human rights violations and encourages national jurisdictions to strengthen the rule of law by adjudicating these cases in their own legal systems. This principle has been put into action by the International Crimes Division of the High Court of Uganda, and with the work of the ICC increasing, may be applied in several other countries. To date, 34 African states are parties to the Rome Statute, which demonstrates the importance placed on accountability and the principles of international criminal law. In fact, many legal systems in Africa have also integrated international criminal law principles into their national legal systems. For instance, the aforementioned Ugandan High Court's International Crimes Division may prosecute genocide, crimes against humanity, war crimes, and other international crimes, while the Democratic Republic of Congo has established mobile gender justice courts. In 2003, South Africa adopted the ICC Act, which defines international crimes, dispositions regarding international cooperation, the exclusion of immunities, and the necessity of legal reforms. Senegal modified its Code of Criminal Procedure in 2007 and introduced both the complementarity and the cooperation principles and illustrated the relevance of domestic implementation in a monist legal system. Furthermore, the renewed discussions that are taking place in the African Union regarding the merger of the African Court of Justice and the African Court of Human People's Rights, and giving this amalgamated court jurisdiction over international crimes pushes one to reflect about the potential advantages of regional criminal courts. Such tribunals could be more accessible in terms of geographic proximity and could limit the cultural barriers, thereby facilitating the harmonization between these tribunals and national jurisdictions. Moreover, the 2011 draft protocol on the amendment to the protocol on the Statute of the African Court of Justice and Human Rights not only foresees the creation of a third chamber with international criminal jurisdiction, but also supports the principle of complementarity and envisages the extension of the scope of international crimes to include illegal trafficking, corruption, and piracy. Such development of regional criminal courts could result in a broader expansion of international criminal law based on the principle of complementarity and supporting the idea that national jurisdictions would adjudicate cases involving international crimes, with the ICC remaining, as it was intended, to act only where national courts, or if the case may be, regional tribunals, are unable or unwilling to do so. I look forward to future discussions about the creation of regional tribunals and the potential expansion of the African Court of Human and People's Rights to prosecute individuals for international crimes such as genocide, crimes against humanity, and war crimes. If these proposed courts are created and provided with jurisdiction over international crimes, they could run complementarily with international tribunals, resulting in an effective justice mechanism that would act as another deterrent and reduce the need for preventive intervention for the maintenance of international peace and security. In terms of the creation of these courts, and based upon my experience at the ICTR, I can unequivocally say that Africa has the professional capacity, infrastructure, and leadership to run such courts under the highest standards. However, the creation of these new criminal justice institutions will take time, extensive planning, and, as the ICTR knows all too well, a considerable amount of financing. Therefore, until new judicial institutions are created and until justice can be ensured in local or regional courts, I must join the voices of such respected leaders as Archbishop Desmond Tutu and former UN Secretary General Kofi Annan, who continue to advocate full cooperation with the ICC so that the victims of the most serious crimes are heard and so that justice can be served. However, the role of the ICC and its current relationship with certain African countries may also alter the framework of international judicial institutions as we move forward. As many of you are aware, the African Union, AU, recently held an extraordinary summit to discuss the ICC and in particular the case against Kenyan President Uhuru Kenyatta. The AU has criticized the ICC for what it describes as selective prosecution against African countries and has requested a deferral pursuant to Article 16 of the Rome Statute of the trial against President Kenyatta and Deputy President Ruto for 1 year. Article 16 of the Rome Statute empowers the Security Council to pass a resolution under Chapter 7 of the Charter of the United Nations to defer an ICC investigation or prosecution for a renewable period of 12 months in order to maintain or restore international peace and security. The Council has not previously deferred an ICC prosecution pursuant to Article 16, including when the AU previously sought to block the issuance of the arrest warrant against Sudanese President Omar Al-Bashir under Article 16 of the Rome Statute. As I said earlier, judicial institutions must be seen to be doing justice by the people affected if the judiciary is to be respected. And international courts and tribunals cannot succeed without the support and cooperation of the international community. President Kenyatta and his Deputy President William Ruto have both been charged with crimes against humanity, alleged to have been involved in the violence that followed the Kenyan presidential elections in 2007, which killed more than 1,100 people and displaced more than 600,000. In the continued fight against impunity and, in my opinion, to maintain international peace and security, the international community must continue to hold persons accused of international criminal and humanitarian violations accountable regardless of their official position. This is the exact sentiment that is found in Article 27 of the Rome Statute, which clearly states that the statute shall apply equally to all persons without any distinction based on official capacity. In that regard, Mr. Ruto's appearance before the ICC and President Kenyatta's pledge to cooperate fully in his upcoming trial before the ICC represent a positive step forward in international cooperation between states and the ICC. I also believe that the ICC has made some positive gestures in the case against President Kenyatta and Deputy President Ruto. The President will be excused from certain ICC trial sessions so that he can continue to perform official duties, although a review of that decision has been requested, while the Deputy President will be excused on a case-by-case basis and only when it's absolutely necessary. Such flexible arrangements not only reinforce the power of the ICC to hold the most powerful accountable, sorry for this, but also allow a case to proceed despite challenges related to a person's health or official status. These arrangements are another example of the evolution of international law and demonstrate the importance for international and domestic courts to adapt flexible solutions to ensure that justice is not only done, but also seen to be done by the international community and those most affected. In addition, while I believe that the AU made the right decision not to vote to withdraw from the ICC, I do not agree with its contention that charges should not be commenced or continued before an international court against any serving heads of state or government. As a judge who has overseen international trials against high-ranking government officials, I must echo the sentiments raised by many, including international human rights organizations, that granting sitting heads of states immunity will undoubtedly lead to an incentive to gain and stay in power by any means necessary. Moreover, hindering ICC investigations and prosecutions will only delay or prevent justice for the victims of violence in situations under investigation by the ICC. Next, while I fully support the ICC, I do believe that the concerns expressed by the AU and other African leaders surrounding the notion of selective prosecution by the ICC must be taken seriously. A withdrawal by any group of state parties to the Rome Statute would have a significant impact on the future functionality of the ICC and limit the ability of future victims of international crimes to obtain justice. While I know that the ICC does have preliminary examinations underway outside of Africa, including in Afghanistan and Colombia, the court undoubtedly will continue to be subject to criticism if it fails or is unable to investigate and prosecute leaders of the most powerful countries and those governments the most powerful countries protect. Though these issues are a microcosm of global politics, and certainly not the fault of the prosecutor, who has been invited to investigate crimes in many of the countries where prosecutions are currently underway, it does provide more context to the recent discussions about the AU's withdrawal from the Rome Statute. As a result of the recent extraordinary summit and concerns regarding the role of the ICC and its relationship with Africa, I continue to believe in the significant investment in the development of domestic and regional courts and judicial capacity building at the domestic and regional levels. After all, the success of any court relies on the capture of the accused, which has proven to be difficult for all tribunals, including the ICC. To this end, perhaps regional courts would have greater success at garnering cooperation from the places where fugitives from justice find haven. Moreover, in strengthening the capacity for domestic courts to try those accused of international crimes, we naturally enhance their capacity to fill the immense void which is currently only partially filled by the ICC. True complementarity, whereby the ICC relies on national and regional courts to try those they can and refer those they cannot, is the real future of international justice, in my opinion. Thus, I hope to see international justice mechanisms following the complementarity approach and the future expansion of national jurisdictions over war crimes, crimes against humanity and genocide. However, it might become necessary to once more form specialized tribunals like the ICTR, ICTY, or hybrid tribunals when a particular situation arises that neither national courts nor the ICC or regional judicial institutions are able to handle. Sadly, it is hard to turn on the news and see footage of mass atrocities and gross human rights violation occurring around the world and not wonder whether ad hoc tribunals, ad hoc international or hybrid tribunals may be necessary once more to fight against impunity. In that respect, the lessons we have learned at the ICTR and ICTY may serve as guide for the creation and implementation of future ad hoc international or hybrid tribunals, should they ever become necessary. As I look back upon the lessons learned at the ICTR, I'm also reminded that the lasting legacy of the ad hoc tribunals will always be their commitment to the sentiment of never again, as well as the unwavering message they send to the international community that flagrant violations of international criminal and humanitarian law will not go unpunished. I'm honored to be part of the rich legacy of the ad hoc tribunals and the contributions these tribunals have made to international criminal justice. I look forward to further discussions by the esteemed panel members on some of the topics I've addressed here today, and wish to thank you all for your participation in this conference. Thank you.
I would really like